Mr. Armstrong is here today after failing to appear before referee Nets on October 16th, 2020. Bond is currently set at $10,978. This is the 11th bench warrant. He reports that he is employed at Champs. The last payment made on this account was in September of 2019, and that was a $1,000 bond forfeiture. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on June 26, 2024 at 8:00 a.m. before this court.
Thank you. Mr. Armstrong, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on June 26, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
What's the bond? I don't.
Okay. Well, that's what we're going to do. That's what we're going to set today. Court does note that you have obviously a very substantial arrearage in this case, and you now haven't paid going on 5 years. So, and you have prior 11 bench warrants in this case already. So the court does have some concerns with that. I am going to reduce your bond in hopes that you could be released, but what I'm going to do is set your bond in the amount of $1,500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
Thank you.
Jeff, I was informed by the jail that Mr. McCormack is refusing to come to this hearing.
Okay. We'll see if he wants to do it on Wednesday.
He must know you, Mr. Chapman.
Knows he's not getting off easy today, huh?
Yeah. Okay, anything else?
Nope, that's all for today then.
Okay, we'll see you Wednesday.
See you
Court
Wednesday.
will note the appearance of Ms. McNiff on behalf of plaintiff. This matter is before the court on the plaintiff's motion to modify temporary custody, parenting time, and support. Ms. McNiff.
Your Honor, I would start by saying that the last time these parties were before the court with regard to child support was about a year ago. Since then, Ms. Keeler no longer has a part-time job. Her sole income is Social Security disability, and she receives $816 per month. The disability income for the child goes directly to Mr. Miller. She's currently ordered to pay $364 per month in child support, and that's based on an imputation of this court at $15 an hour for 40 hours a week, which simply isn't accurate at this time since she no longer has a part-time job. Her part-time job was of the nature that she could still maintain her Social Security income plus that part-time job, but now she's down to the $816 a month. So that is a material change of circumstances, and child support should certainly be revisited in order to straighten that out. That's a significant portion of her income that she is required to pay in child support. Mr. Miller has argued that Ms. Keeler still has an alcohol problem, still has anger management issues, and shouldn't be permitted to see the party's minor child without supervision. However, the court can certainly prohibit Ms. Keeler from consuming alcohol prior to or during any visits. The court could also require that Ms. Keeler have visitation with the minor child in public places or with other appropriate adults. I don't know that we need a foster care worker in order to supervise those visits. Again, a year has passed. There have been changes that should permit Ms. Keeler to have parenting time with the minor child, and the court has the ability to put some guardrails around those visits so that the visitation could be appropriate and the child could be protected. So we would ask that the court restore some unsupervised parenting time to Ms. Keeler with the restrictions on alcohol. We believe that standard parenting time is appropriate, but perhaps there could be a graduated schedule so that she could prove herself to Mr. Miller and to the child that she is able to maintain her temper and maintain sobriety. So we would ask for a standard parenting time schedule that could be a graduated process.
Okay. Mr. Miller, what's your response?
Good morning, sir.
Morning.
We're not opposed to the review for child support. I think that needs to be filed with the Office of Child Support for a review. But in regards to the parenting time, Ms. Keeler hasn't completed any of the obligations that CPS required. And my fear is not only for, the child's safety and what she might do in no one else's presence, but that CPS will reopen this case once they find out he is in her care for any amount of time. They made it clear that the only reason the case was closed was because she had lost custody and no longer had parenting time. So we would be opposed to that unless it was supervised. And the person that I was asking to supervise in my response, Helen Miller, is a licensed foster care worker, true, but she is also Keon's grandmother.
Okay. What are your thoughts on that, Ms. McNiff, is to have the grandmother supervise?
Ms. Keeler is not in favor of having the grandmother supervisors. There's not a good relationship with the grandmother, and she would prefer some more neutral person. If the court is going to order supervised parenting time, that it be somebody who's more neutral.
Okay.
Your Honor, if I may.
Yeah, go ahead.
I've been working with April's parents, Ray and Bonnie Keeler. I do trust them. I believe they would also be suitable.
Okay. Well, Ms. McNiff, how about the maternal grandparents? Would that work?
That sounds reasonable to me, Your Honor.
Okay. Well, as Mr. Miller said, he does not oppose a child support review, so the court will send the matter to the referee for a child support review. As it relates to parenting time, the court likewise has no problem with, again, a standard parenting time schedule. Again, basically on alternating weekends and a midweek. I'm not going to do it for the any weeks period in the summer, because the court is going to order that it be supervised by the maternal grandparents in this matter. And obviously that would just be asking too much if we're going to have to make it a week long or for extended parenting time. So we'll do it gradually. We'll do the standard alternating weekends in the midweek and alternating holidays. But I'm not going to do any extended at this point. Ms. McNiff, you can prepare that order and submit it under 7 day.
Thank you, Your Honor.
Okay. Thank you both. You're free to go. Have a good day.
You too. Thank you.
9:07 a.m.
Okay. Court will note the appearance of Ms. Smith on behalf of the plaintiff. The defendant is not present. The defendant, we believe, had attempted to connect a few times, and we were not able to get a connection with the defendant. What I'm going to do, because I obviously, if he's not able to connect, I'm not going to, again, prejudice him as a result of that. The matter is before the court on the plaintiff's motion for temporary spousal support. I do note under paragraph 7 of the petition, Ms. Smith, that you do list 5 different factors that the court should consider, but all I do is draw your attention to Sparks v. Sparks and the Louts case. Sparks has 12 factors the court has to consider. Louts adds 2 additional to make that 14 factors. And the biggest factor that's missing is the needs of the parties, and you didn't include any budget or anything so that I can tell what Ms. Smith's or Ms. Okudo's needs are in this particular matter. So what I'll do is allow you to amend your complaint, renotice it, and that way then we can maybe get Mr. Okudo to join at that time as well.
Okay, thank you, Your Honor.
Okay, thank you. Have a good day.
7 a.m. You too.
Court will note the appearance of Ms. Reiser on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for a parenting time arrangement. Ms. Reiser.
Good morning, Your Honor. As you said, this is plaintiff's verified motion for a temporary parenting time arrangement. The parties have never been married. They have 1 child. He is approximately 1 year old. Dad's on the birth certificate. He signed an acknowledgement of paternity. Dad has 4 other children from previous relationships that travel freely between households. The parties separated, and I believe it was March of 2023. And they have just kind of been exercising parenting time as agreed. But a few months ago, mom stopped letting dad see the child consistently. So there's a need for at least a temporary parenting time arrangement until we can get something permanent in place. I would like to assume that you've read the motion, but I'll hit a few highlights of the best interest
I
factors.
have read the motions. I have read the motion. You don't have to be redundant.
Okay, thank you, Your Honor.
Yeah.
So Dad is asking for week on, week off parenting time. He has a work schedule that allows it. As I said, he has 3 other children. His biggest concern is that mom leaves the child at her dad's house for like a week at a time. And he feels as though the child should be left with him rather than maternal grandfather. Dad's able to accommodate the child's needs. His work schedule is a lot. He can care for the child. And yeah, he's looking for week on, week off parenting time, holidays pursuant to the Calhoun County guidelines. We get child support could be referred to the friend of the court. We don't know if mom's working. We know she lost her job recently with Target. There are concerns that she is dating a felon. And so he's concerned with who the child is around. He has stable housing. Both parties actually have stable housing. So we're asking for a temporary parenting time arrangement of week on, week off. I thought we had this resolved. I actually prepared a consent order that said week on, week off. Mom was concerned with the term joint legal custody. I tried to explain that that is not an unusual, that's pretty common. And then it just has to do with major decisions, medicine, education, religion. But also I don't want to overstep my bounds since I'm not her attorney, so.
Okay. Ms. Brandes, as stated by Ms. Reiser, again, a joint legal is pretty standard provision, means that the parties have to discuss and communicate concerning important decisions concerning the child. They don't always have to agree to those. If you can't agree, then you bring the matter before the court, but you are required to discuss and communicate important decisions. So what's your position, Ms. Brandes?
I just think that he should get every other weekend. We've done fine with doing that recently. I don't see why it can't stay the same. I don't think he's fit enough to keep Maverick week on, week off. He doesn't keep his other kids that long, ever.
Okay. Is the child going with the maternal grandfather on alternating weeks?
He was here, so I worked four days on and then had 3 days off. He was here 4 days out of the night when I was working second shift. Yes, my babysitter is 50 minutes away. I wasn't driving here at 2 o'clock in the morning to get him.
Well, at this point, what the court will put in is just a temporary parenting time. And the court does note that the parties were separated back in March of 2023, that they've been doing all sorts of different things. So what the court will do is the court will grant to the plaintiff at this point the standard parenting time, which is alternating weekends, midweek, et cetera. Ms. Reiser, you can put that in that the midweek would commence this Wednesday on June 12th, and that the weekend would commence on June 14th. And then we do alternating holidays. We can do, again, the court would order, I don't see any reason that he couldn't have his alternating weeks in the summer. As Brandes, typically we do grant alternating weeks in the summer. What are your, do you have any position on that?
I mean, I wouldn't disagree on that until school starts.
Okay. Well, there's no disagreement. The court will order that. We can attempt to, maybe we can get back in and review this prior to the time, be at the end of the summer at that point. Court will order that the parties would exchange income information within 7 days of today's date. And then as a result, Ms. Reiser, you can calculate the child support.
Okay, and just to clarify, so I believe summer break has started most places, so we can start week on, week off.
Why don't we start that on the would have been his weekend on the 14th.
Perfect. All right, thank you, Your Honor.
You have any questions, Ms. Brandes?
So are we starting week on, week off now or every other weekend?
No, we're starting alternate. We're in spring, we're in summer break. So we'll start the week, alternating weeks this Friday, the 14th, and then we have the midweeks on this Wednesday.
Okay.
So what'll happen is, again, you'll get a midweek on the weeks he has the child. He'll get a midweek when you have the child.
Okay.
Okay? And you need to provide Ms. Reiser with your income information within 7 days of today's date so she can calculate child support.
Okay.
Ms. Reiser, then you can submit the order under 7-day notice of entry once you have that.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Thank you.
Bye-bye.
At 10:06 a.m.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. White on behalf of defendant. This matter is before the court on the plaintiff's amended objection to referee recommendation. Mr. Schaefer.
Please, the court, Your Honor, within the time period an objection was filed, we're asking the court to de novo review the matter herein. This is a little bit different. The transcript has been ordered and received of the finding on April 12th of 24. This matter involved, I believe, at least 3 hearings on May 31, 23, 9, 28, 23, 12, 8, 20. And unfortunately, it had different referees during that time period. And there was some only with the recordings on 1/16 of this year. Your Honor ordered that all of the hearings videos be made available to the parties, so they have been made available, and I think are available for the court's review.
Okay. But we only, Mr. Schaefer, we only have transcripts of the one hearing then. Is that correct?
Yeah, my understanding, there's only been transcript, and that is the finding hearing on 4/12 of 24. That was when the referee made the determination and the ruling. But it goes back to the other 3 hearings that Your Honor ordered on 1/16 of 24 to be made available. So they've got to be available to the court also.
I have that the referee made a finding on 3/12/24. Do you just have that date wrong, or?
Well,
That's the transcript that I received.
excuse me. The referee finding hearing, I'm looking at the transcript, and it says Friday, April 12 to 24.
Okay, well, maybe you just had the date wrong or appeared someplace wrong. I don't know.
Good.
But I did review the referee's finding in this matter. So Mr. Schaefer, what are you asking of? Obviously, we have that finding and the court has reviewed that. Are you looking for, on your de novo, for presenting additional witnesses that could not be presented previously, or just a review of the record?
A review of the record, Your Honor, on including the 3 dates that I have mentioned.
Okay. Can you get, are you getting a transcript of those dates, Mr. Schaefer?
I will order those, Your Honor, although I think the court has those in the file because you ordered them before, and I think they have been made available in the court file. That was my understanding.
The transcripts?
No, I think the actual videos, some of the videos were not coming through and not available at that time, and we had to go to the court to get those prepared. Mr. Snyder was not able to retrieve those right away. But if your court wishes transcripts, I will order those transcripts.
Yeah, I want transcripts, Mr. Schaefer, so they can read those. I do find them easier to read than to sit through all of those videos. Plus, it's easier for reference as well.
Okay, very good.
With that, Ms. White, is there anything you have other than waiting for the transcripts?
Yes, Your Honor, I would like to make a couple comments. I see that there was an objection filed on May 1st, but I was not served with that objection. The one objection I was served with is dated May 23rd, improper by Ms. Herman, plaintiff. And there's no notice of hearing date. It just says Zoom with Your Honor. I had to look it up on the Register of Actions last Wednesday when I got it. So I would like to reserve an answer should it be necessary for me to file one. I also want to state that we have resolved that issue with the different referees. I believe, I didn't think I'd have to do a hearing count, so I didn't prepare that for this morning. But I believe there are 5 hearing dates, Your Honor. The first one was with the first referee. The second one was partial. There was something wrong with the recording, so it got adjourned. And then I believe we had 3 hearing dates after that. Now, the first one, the referee said he went back and actually listened to that testimony before he issued this recommendation. And the other thing we did, Your Honor, is we redid opening statements. We redid testimony for the time that there was a missing record. So I don't, when I looked at the objection, at least the one that I have, basically it's just a question of whether the referee can assess credibility of the witnesses, which I believe they can. There's an objection regarding factors B and H that were materially testified about on both direct and cross-examination. And in regards to paragraph 3 of this objection, it references testimony that's from evidentiary hearings. This isn't the first time this case has had more than one evidentiary hearing, just since 2021, I believe. 2020, 2021. That paragraph is referenced to allegations from the first set of the evidentiary hearing before the motion for a change of custody was filed in November of 2022, which is what this one is related to. And so, it's a little bit frustrating because it was extensive. We went through this, Your Honor, extensively. And so, yeah, I do request that all of the transcripts be provided if you're going to review them, because I don't think there's any material objection to the findings. And any hole in the record, especially from hearing number 2 and a change in referees, was more than adequately addressed during these.
Well, we'll have to get the transcripts, I guess, to determine that. So I'll have Mr. Schaefer acquire the transcripts, provide Mr. Schaefer to Ms. White all of the objections that you had, because apparently she only got the one objection, which would have been the last one that looked like it was filed in pro per. So make sure she gets those objections as well. And once you have the transcripts, provide those to the court, and then we can reschedule the matter, Mr. Schaefer.
Okay, very good. Thank you.
Okay. Thank you all. Free to go. Have a good day.
Thank you, Your Honor.
You look good today.
Are we in the waiting room, Mom?
The 37th Circuit Court is now in session with the Honorable Brian Dana Allen versus Michael Noble.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the plaintiff's motion for entry of order determining child born out of wedlock. Ms. Allen, in this case, before we can do that, we're going to need an evidentiary hearing. And I do note that we do have in the file an order for genetic testing. I assume, Ms. Allen, that hasn't been done yet?
No, it hasn't been done. But the biological father has moved to Georgia. But he also has 2 child support cases out of Kalamazoo County. And I am acquaintances with one of the other mothers, and she did say if worse comes to worse and it's an option for me, that she would consent to like a sibling DNA test if that's even possible. But he is out of state in Dalton, Georgia now.
Okay. And what's the name of that individual, Ms. Allen?
The father?
Yes.
Dakota Torres.
Okay. Well, the court will order the genetic testing of, again, Ms. Allen, you, the child, and Mr. Noble. We can at least, if he's to be excluded, we can exclude him. And then you'll have to follow up with Mr. Magnuson on Mr. Torres.
Okay.
So, Mr. Magnuson, I think you put in an order for genetic testing, or was that you, Ms. Allen?
I put the order in.
Okay. Okay.
That's correct. That's correct, Your Honor.
Okay. Ms. Allen, why don't you do that? You can call Mr. Magnuson at the front of the court's office after this hearing and coordinate when you can get in to do the genetic testing, and then let Mr. Noble know as well, and then he can get in and do the sample, and we can get that, at least get that part resolved.
Okay, that will be fine. I can honestly, is it appropriate for the testing if Michael was incarcerated and I can prove that? Or do you still want it done anyway?
Oh, so, well, Mr. Magnuson, I guess it would depend on the time of conception based upon the age of the child. If, let's say, for instance, he was incarcerated until, 2 months before the child was born, obviously he couldn't be, the biological. So we wouldn't need to do the testing if in fact the facts would bear that out. I just, based on what's been filed, I don't know what those facts are yet.
So, I guess I filed it wrong. I was gonna ask for the genetic testing to be in order for Dakota and not Michael, because Michael was incarcerated March 22nd of 22. I got pregnant in June of 22, and my daughter's 1 year old, and Michael just got released from prison in April of this year.
Okay, well, Mr. Magnuson, do you acknowledge that there's probably no need to have Mr. Noble attested?
It sounds like it, Your Honor, based on what is being represented.
Okay,
I'm just kind of looking forward. If those are the proofs that come out at the hearing, I'm guessing that
okay,
clear and convincing evidence standard would be met.
yeah. What we'll do, Miss Allen, I'll have you after court, you can call my office and we'll set you up. We do those hearings on Wednesday afternoon at 1:30, and we're gonna need more time when we can take some testimony, because I have a number of hearings today and I can't take testimony today.
Okay.
So, if you'll call and know, and then if you can relate that to Mr. Noble, we'll have him come in and he can testify as well to those facts. And then we wouldn't need to have testing of him done, but I'm sure Mr. Magnuson will require that there be some testing of Mr. Torres.
Yeah.
And, as you proceed.
Absolutely.
Okay, but Mr. Torres at this point is not added to this case, so you'll have to file a separate action against Mr. Torres.
Okay. Yep. No problem. The prosecutor's office should be able to help me with that. Honestly, I tried to do a separate case the same day I filed this ROPA, and they told me that I didn't need to do that because I was on assistance, and that the FOC and prosecutor would work with me to open a new one for him. So.
Well,
That's correct.
okay,
Okay. Awesome. Thank you so much for your
thank
help.
you. You're free to go.
Yeah.
Have a good day.
You too.
Thank you.
Thank you.
Thank you, Your Honor.
2024 at 10:40 a.m.
Court will note that both parties are here representing themselves in pro per. This matter is before the court on the defendant's amended motion regarding custody. In this case, court will note that the plaintiff did file a complaint for custody, parenting time, and support. Defendant has filed an answer to that. Mr. Nichols, it sounds the custody will be addressed in the course of that case as we proceed. It sounds like, based on reading of your motion, that you're asking for parenting time at this time. Is that accurate?
Yeah, that's correct.
Okay. And Ms. Tidwell, what's your response to the request for parenting time?
I'm willing to agree with parenting time.
Okay. And how old is the child?
He just turned 1 April 18th.
Okay. Well, typically, Ms. Tidwell, just so you know, that the typical standard parenting time is alternating weekends from Friday at 6 to Sunday at 6, then a midweek from 4 to 8. Usually, if the parties can't agree as to the day, it would be a Wednesday. You can agree upon another day if you can, but if you can't, it'll be Wednesday. And then typically, too, is standard for children other than small children is alternating weeks in the summer. What you said you're agreeable to parenting time. What parenting time are you agreeable to?
About every other week.
Alternating weeks?
Yes.
Okay. Okay. Mr. Nichols, I assume that would be agreeable to you.
Absolutely.
Okay. Why don't we do that? And Mr. Nichols, you'll have to do an order for parenting time and put that, again, that you would have alternating week parenting time, and that will commence this Friday, June 14th at 6:00 p.m. through the following Friday at 6:00 p.m. And then we alternate each week thereafter.
So I have a question for you.
Yep.
So I would get him this Friday?
Yes.
Okay, awesome.
You get him this Friday, and what we'll do is, we don't need to do that this time. There's a midweek, so each party, so Mr. Nichols, when you have the child, she would be entitled to a Wednesday midweek from 4 to 8:00 p.m.
Okay.
And then on her weeks, you would be entitled to a midweek. And then you would also be entitled to alternating holidays. And there's standard alternating holidays through the front of the court, and you can look online and get that information. But because you're representing yourself, you'll have to do the order for parenting time, and then you'll have to submit that within 7 days, and then you don't need to have an additional hearing. If you don't get it submitted within 7 days, then you'll have to motion the matter up for entry, and it'll require another hearing. So I don't know if you're using like Michigan Legal Help or something of that nature, but you can go to michiganlegalhelp.org, and they have all those orders and forms and stuff online, and you should be able to just prepare one with alternating weeks, midweek, and alternating holidays.
How about child?
What? Yeah. So, and you can put in this matter, you can do a calculation of child support as well, based upon the alternating weeks. I don't know if the child is receiving any public assistance, or if mom.
Yes, he is.
What?
Yes, he is.
Okay. Then what's going to happen is we can't deviate from the standard calculation. So, Mr. Nichols, you'll have to do a calculation of support based upon what each of your respective incomes are. Court will order that each of you would disclose the income no later than this Friday, the 14th. That way, Mr. Nichols, you can do a calculation, and you can get it in the order, so you can get it submitted before Monday. Okay, so you don't have to renotice it up. Okay, and you can do that through Michigan Legal Help as well. Do the calculation. Okay. So, Ms. Tidwell, you'll have to get him your income information. He'll provide you with his income information, most current, up to date, year-to-date income, and then he can calculate the support and submit an order for the parenting time and an order for child support as well.
Okay.
Okay. Thank you both. You're free to go. Have a good day.
Thank you. You too.
Okay, let me try chatting.
Well, get plaintiff on, and that she can identify whether this is the
That's-
defendant.
I'm trying to get her to start video here. Motorola, can you please connect to audio? Okay, do you know if this is Mark Bond right here?
It is, yes.
Okay, it's having a hard time connecting to audio.
Both parties are appearing in pro per in this matter. The plaintiff has filed a motion to show cause, claiming denial of parenting time in this matter. The court does note, I've reviewed the judgment of divorce. It provides that the defendant will have the first 3 weekends in the month. That's your understanding, Ms. Bond?
Yeah, the way that we have it set up is that we have parenting time as agreed, and if we don't agree, then dad will have parenting time 3 weekends a month. Yes.
Okay. Well, the problem is that the judgment doesn't identify those 3 weekends, so I can't hold anyone in contempt when the order isn't clear, and there is obviously open to confusion. So what the court's going to do is the court's going to clarify that judgment of divorce and provide that the defendant's parenting time will occur on the first weekend of the month in which all of the days fall within the particular month. So in June, the first weekend would be starting June 7th, 2024. And then for the next 2 weekends, And then the other weekends of the month would go to the plaintiff in this matter. You understand that, Ms. Bond?
Yeah, the problem that we have right now is Mark has decided that Abigail is going to have full-time parenting time with him.
Okay, well, if he's gonna do that, he's gotta file a motion. Sir, you can't have that. You gotta follow the judgment. And unless the judgment's changed, so you're gonna have to file a motion.
Okay, may I speak?
Yep, go ahead.
Okay, I am not keeping my daughter from going to her mother's. My daughter is 16 years old. My daughter has on her own decided that she wants to be with me full time and visit mom on weekends because of the problems that the two of them have.
Okay,
So my daughter has chosen, other than me physically picking her up and putting her in the car and making her go, my daughter is choosing this on her own at 16 years old.
okay. Well, as a parent, you have to show guidance and you have to basically show her that she's gonna have to go with mom. And
Your Honor, this has been ongoing for 2 years. First of all, for almost 2 years, we haven't been doing the weekend thing. We've been doing a week with me, week with her for almost 2 years. So what's in the court papers hasn't even been in effect with us for almost 2 years.
that may be, sir, but the only thing that, sir, stop. The only thing the court can do is enforce the order, and the judgment provides for the 3 weekends. That's all I can do. I can't enforce something that the two of you have come up with and that you're doing or not doing. I can only enforce the written orders. So that's all that I can do at this particular time, unless you file. If you file a motion to change the orders, then we can address that. But that's not before the court today. And so at this point, I'm not finding you in contempt, sir, because the judgment wasn't that clear as to the parenting time. I'm attempting to clarify that, saying that the plaintiff's parenting time will be those 3 weekends, the first 3 weekends of the month, starting with the first weekend in which all of the days fall within that particular month. So that's what I can do today. If in fact there's not compliance with that, then we can look at, again, show causing once the order is clear. And sir, I will just caution you that obviously if you're not assisting in the parenting time occurring, you could be held in contempt and you could go to jail. Then the child would have to go with mom because you wouldn't be there to have custody.
All right.
Okay?
And so, I mean, and that's all well and good. What's the paper you said I have to file? Because this has been going on for 2 years. This is my daughter has been talking to me and has talked to her mother on a couple different occasions.
What you're gonna have to do, you're gonna have to file a motion to modify custody. And effectively what you're seeking to do is, file a motion to modify parenting time in this matter.
Okay.
So, and it'd probably be a good idea for both of you. I don't know if you want to look at that now. If there is a problem between the plaintiff and the child, maybe you should seek some sort of counseling. Have you thought about that?
Yeah, that is something that I've actually, since this started in April, is something that I've wanted to do, but I've not had her with me to be able to do counseling with her.
Okay, well, the court can order that the defendant would take the child to counseling, and we could set it up with the counselor, and what would be called as reunification counseling. So, sir, do you have any opposition or objection to the counseling?
Well, I would probably recommend that we allow the family court judge to discuss some of this with my daughter.
Okay.
So that she has a voice in this at 16 years old.
I'll tell you, sir, unless she testifies, that can't happen. The court cannot have communication. The only time a court can talk to a child is when there's a custody dispute and the court is attempting to discern the preference of the child. I can't talk to the child about disputed matters because it's not appropriate and I'm not permitted to do that.
Well, and I understand that, and I will have that motion filed today for custody modification.
Well, parenting time too.
Yeah, that's yeah, okay, that's yeah.
You can file that and we can, at that point, if you want to put in that there would be, I guess I'll ask, sir, are you agreeable to counseling so that maybe we could get the counseling started?
You know, I would have liked this 2 years ago when my daughter first started talking to her mother about this.
Well, I'm asking you now.
Because she's blaming me for not allowing her to go, and that's not the case. I'm just strictly not picking my daughter up.
I understand.
In
Okay,
my car
we're past
and
that.
making her go.
We're-
16
we're
years
past
old. It's
that
not
now,
going to happen.
sir. We're past that. I'm looking. Are you agreeable that the child can participate in counseling, reunification counseling with the plaintiff?
If my daughter is willing to do so, yes, I am.
Okay. Well, let's do that.
Because
Ms.
at
Bond,
16,
the court will order that there be reunification counseling. And I'll leave that up to you, Ms. Bond, because you're the one initiating. You can get the name of the counselor that you're going to be doing. Provide the defendant with that. You can do an order for counseling. And then what will happen, the court would order that both parties would pay 1/2 of the cost of the counseling not covered by insurance. And
Your Honor, I'm on disability and I cannot afford that.
well, then you have to, there might be somebody, like if you go through like Summit Point or someplace like that, they would have some sort of means tested and they would, it would be based upon your incomes, et cetera. So you can do that.
I can't afford it. Can't even afford an attorney for this, so.
Well, do that, Ms. Bond, you can get the order and again, try get it through a place like that, like Summit Point, that wouldn't have, basically would charge based upon the incomes of the parties. And, you know, some case when a person can't afford it, they don't charge anything. So that might be what happens in this case. So do that and we can get the counseling started right away. Mr. Bond's going to file his motion. I will tell you, Mr. Bond, that when you file the motion, file it, set it, but obviously with the order for parenting time, counseling, if you would, or reunification counseling, the court's probably not going to do anything on that motion until we've had some sufficient time for a counselor to meet with all the parties. And I will tell you, Mr. Bond, it's to your benefit to have the child go to counseling, because if she tells the counselor she doesn't want to go, the court will take that into consideration.
Oh, and I understand that, and I've, you know, strictly have just followed my daughter's lead on this. You know, this is
okay. Well,
the last
I will
thing
tell you, you're the parent, you're the one to lead, not let a 16-year-old lead, because we don't know what that'll lead us to. Okay?
My
So,
daughter's
Ms.
happiness
Bond,
is
you can
number one.
prepare that order, submit it for the counseling, and then he'll submit his motion, and then we'll go from there.
Okay,
Okay? Thank you both. You're free to go.
Sounds
Have a good day.
thank you.
We're at 11:02 a.m. The petitioner is not here.
Okay. This matter is before the court on the respondent's motion to terminate. Mr. Osselton, as I look at the file, I note that the personal protective order was entered on February 8, 2024. You were served personally on April 2nd, 2024, and you filed your motion on May 17, 2024. Is that accurate?
No, Your Honor. I was never served anything. The only reason I found out about the PPO is I got a letter in the mail from the court stating that I had a PPO. I've never been served anything by Zelda or any of her representatives or any other person at that. I've never signed for anything.
Okay, hold on. Let me.
The only thing that I've been served by the petitioner was the divorce paperwork that we're doing in another case.
Okay, let me see. They claim that you were personally served. I'm looking at the proof of service signed by Hetty. I can't make out the last name.
It looks like Maston, M-A-S-T-E-N.
Do you know this Hetty Maston at all, sir?
No, Your Honor.
Well, there was another issue. Did you get, initially, we had that there was no proof of service served on Miss Puzzleton.
I
Go ahead.
I sent the certified restricted mail to her on May 17th. I still have not received the certificate from the post office yet.
Okay.
I sent it to the last known address that I had for the petitioner. I'm not sure what her address is now, but I tried to do everything the right way. I worked with you guys as clerks and they helped me get all the paperwork done.
Well, I can't proceed today until we have a proof of service, okay?
Okay.
Because I can't proceed unless she's been served. So what you're gonna have to do is get that proof of service, and then what you're gonna have to do is renotice the hearing, and that way it gives her an opportunity to be present. She can have that the person that claimed to have served you with this matter, they can have that person present, and they can testify too if they want to. If not, then but I can't proceed because we don't even know that she was served yet.
Okay. So how would I go about, because I have sent the paperwork to her through that, like I said, the restricted, certified. So I don't really know how all this stuff works, to be honest with you, Your Honor.
Well, you're gonna have to get back the proof of service from the post office where she signed for it. And then you'll have to do a renotice of that hearing on your motion. Unfortunately, you'll have to serve her again with that, but if she has an address, et cetera, and she was served, then you could serve with the renotice at the last known address. Okay?
Okay, yeah, that's what I did originally. It was just the last known address.
Yeah, that's fine. But do that, and then we'll know that she's been served at least with the original motion.
So at this time, everything stays the same.
Everything stays the same. I can't do anything until we know if she's been served or not.
Okay, Your Honor. I will do whatever I can. So will that just be refiled through the clerk?
Yeah, yep.
Okay, so everything I already did, just resend that paperwork.
Resend it with a new notice of hearing. Get it out enough time so you can get the notice back if you do. Okay?
Okay. Yeah, they
Thank
told me
you.
it would take 15 days if she didn't sign for it, and I still haven't gotten it back, so I don't know.
I can't tell you. I don't know either.
Roger, I understand, Your Honor. No problem. I'll get
Okay.
this taken care of and get it filed as soon as I can.
Okay, thanks. Mr.
Thank you for your time.
In this matter, the court's attempting to determine whether you accomplished service of your motion to terminate on the petitioner in this case. And I can't tell, do you have a proof of service or something showing service of your motion to terminate?
Yes.
And what date was the petitioner served?
Give me 1 second, please. Well, we do have it, but what BPO coordinator says is that we're missing that checkbox where I circled. Other than that, it looks good to me.
It looks like it says personal service. Mr. King, just to clarify, I'm looking at the proof of service. It was filed on May 28, 2024. It looks like it was served personal service on 5/24/24. Do you know if that's accurate or not? The form was, it wasn't clear any of the boxes that were checked. That's why I wonder.
Okay, yeah, that's the date that it was served.
See, I mean, it looks like that they checked that.
I see that on personal service.
Yeah.
I do. I believe that's the text there.
Well, sir, what I'll do is, court does note that it is now 11:12 a.m. It was set for 11 o'clock. Petitioner is not here. She's not filed anything. It does appear from the proof of service that she was served. I don't know what the question was by the PPO coordinator, but as a result, the court will grant your motion to terminate the personal protective order. And do we have those forms or does he have to submit it?
Oh, I'm sending it to you right
Okay.
now. Yeah, the order after.
Yep, the court will enter an order which will terminate that personal protective order, but just so you know, it remains in effect until such time as, we get it signed. So I'll be signing it here shortly, but,
Okay.
what happens is the police agencies won't get it until we file this order. So there may be a delay of, a day or so or whatever. So just caution you shouldn't have any contact with the petitioner because that could cause you to be arrested if nothing else.
Wait, what about being arrested?
Don't have any contact with her until you till that is signed, and it might take a minute for the police officers to get the notification that it's been canceled.
Oh.
But ask him how long before you get a copy of it.
How long until I can get a copy of
So
it?
it's been charged.
You can get a copy of it from the PPO coordinator or from the clerk's office. You can get it today.
Okay. Does that cost anything?
No. Well, to get a certified copy, it will cost you $10 and $1 a page.
Okay.
But part of our procedure is that we mail out copies to the parties. So it's gonna be a plain copy, but it'll go out in the mail probably tomorrow.
Yeah, you'll get a mailed copy, but if you want one before that, then you'll have to come down and purchase that.
Yes.
Okay.
Okay?
Okay, thank you.
Anything else, sir?
No.
Okay, thank you. You're free to go. Have a good day.
No, you guys too. Have a blessed day.
Yes, can you hear me?
Yes, we can hear you now. Okay, thank you everybody for your patience. This is for two cases, Lindsay McKediak versus John McKediak, John McKediak versus Lindsay McKediak, Attorney Shelley Hoffman for the respondent, Mr. McKediak in the show cause matter.
Okay. We'll take that matter first because Ms. Huffman is here and you only, just for purpose of the record, Ms. Huffman, you do not represent the respondent in the motion to terminate. Is that accurate?
That is correct.
Okay. Okay. So Ms. McKediak, you filed the motion to show cause. You can proceed. Would you like to make an opening statement or simply proceed to your proofs?
Just proceed.
And you're going to have to speak up so we can hear you.
No, I don't need to make an opening statement.
Okay. Ms. Huffman, do you wish to make an opening statement or proceed to proofs?
I will waive opening.
Okay, thank you. Ms. McKediak, you can proceed and present any evidence that you wish. If you are going to testify, you're going to need to be sworn in. Do you wish to testify?
Yes, I guess. I don't understand the difference of.
Well, when you file a petition, all there are is allegations. That's not evidence. It's just allegations.
Okay.
If you are going to want to have that be evidence, you're going to have to testify to that. So that's what I'm asking you. Do you want to testify or you don't want to testify?
No, I guess, no.
If you don't want to testify, then the court's going to dismiss your petition because there'll be no evidence for the court to make a determination on.
Oh, okay. Well, then I guess I have to be sworn in.
Speak up, please.
I said then yes, I have to be sworn in.
Okay. Ma'am, what we'll do is we'll have you raise your right hand and we'll have you sworn in and then we'll proceed. Go ahead, Ms. McKediak, you can testify.
Okay. Well, he just calls me when he's drunk and threatens me and threatens my children. And he said that he's gonna bury me. And then he's mad about the PPO. So he that I filed in the first place. So he said he was gonna get a PPO, and he's recently, which
Okay, ma'am, just to clarify, just so we know, because you made various allegations. I don't want general statements. If he contacted you, give us the date and the time when he contacted you as to each time.
Okay, March 18th, and January 20th.
Okay, are we talking 2024?
2024, February 7th, February 11th.
Okay, let's take them one at a time, so then we can get the evidence. So You mentioned the 3/18/2024 first. Let us know what happened on that date.
He called me and told me to go kill myself.
Okay, anything else on that date?
He called me a clown due to the fact that he thought that the PPOs have gotten dropped from the last court date. He called me off of somebody else's phone, so I answered off of.
Okay, again, what date did he call and what did he say?
That was the date in which I'm telling you that he called me a clown and to kill myself.
On the 18th, on March 18th, 2024. Okay.
Yeah.
Anything else that happened on that date?
No.
Okay, what's the next date that we're talking about?
Believe go backwards to February.
February what?
February 7th,
Is that 2024?
2024.
Okay, what happened?
He called me and he said that, you know, he was going to take everything in divorce. I was going to have to live in a box. He says that he'll pour acid all over me so that way I'll never look good for another man and no one will ever want me. And that he's going to make sure me and my kids have nothing. He does this when he gets intoxicated. So it's normally when he does it. When he's not been drinking, then he's usually, you know, well, I don't get any, we don't contact each other, but when he's not been drinking, then
Okay, all that I don't need to know. I just need to know what happened on what dates.
okay.
What happened? What are any other dates that you have?
Yeah, it's February 11th. He was in Florida.
Again, is that 2024?
2024.
Okay. What was said?
Just the same thing. Name calling me junkie loser. And he said that he's gonna have someone come kill me. And he's in another state, so it won't be him, and that he'll get the kids, and just a bunch of nonsense, really.
Okay. Anything else?
No.
Okay. Any other dates that the court has to be concerned about?
Well, I hate having to do this. The other day he called my mother saying that he was going to.
Okay, ma'am. I'm not concerned about him talking to any other third parties. The PPO only keeps him from contacting you. So ma'am, don't interrupt me. I'm trying to explain this to you.
Okay.
He can only prohibited from speaking to you. He can speak to any other third party in the world that he wants to. So I'm only interested about when he's contacted you.
Okay. That's the only reason I brought it up, because it was a threat.
Okay, you've addressed the March 18th, 2024, February 7th, 2024, and I think February 11th, 2024. Is that the extent of it?
I mean, yeah, there's been other dates, but yeah, that's.
Okay, because the court will make a determination based upon those dates once we're through. I want to make sure that you have covered everything that you need to.
Well, just one, that was back in January too.
Okay, what date in January?
January 27th, 2024.
27th?
Yes.
Okay, what happened?
Him and his girlfriend called me and told me to get my ducks in a row.
Hold on, you said his girlfriend called you or he called you?
Him and his girlfriend.
Excuse me?
Him and his girlfriend.
Okay, go ahead.
and told me to get my ducks in a row because it was after I filed and he had been served with a PPO, and he was angry about it. So they were threatening me that he was going to file a PPO back. And
Okay, when you say them, I'm not concerned about what the girlfriend said. I'm only concerned about what he said, because as I told you just a moment ago, I'm only concerned about any communication he has with you.
I'm telling you what he said.
Excuse me?
I'm telling you what he said.
No, you said they said, and I said, I don't care what the girlfriend said. I'm only concerned about what he said.
Okay, well, I guess I meant when he said them, like that they were going to, this is what he said.
Okay, go ahead.
That they were going to, like, that's what I mean by that they were going to file for PPO, and that they were going to file for divorce, and that they were going to get the kids. And so the PPO in which I was served is in his girlfriend's handwriting, and so was the divorce in which that he had filed was in his girlfriend's handwriting.
Okay, anything else?
No.
That's all the testimony that you have to give. Is that correct, Ms. McKeown?
Yeah.
Okay. Ms. Huffman, any cross-examination?
Yes, so you indicated that on February 11th, he contacted you and was in Florida. How do you know where he was at?
Because it was a FaceTime call.
It was a FaceTime call?
Yes.
And so you could see Florida in the background?
I could see, he told me he was in Florida.
Okay, ma'am, keep your voice up because it's hard to hear you. And I'm only saying that because you can answer and say what you want, but if I can't hear it, I can't consider it, okay?
And you said that was the date that he made a threat to you that he was going to kill you, but it wouldn't be him, it would be someone else. Is that right?
Yes.
Do you have oh, scratch that. What time did he call you that day?
And I was in the afternoon. My phone broke, so I wasn't able to get like, I don't have like a screenshot or nothing because my iPhone broke.
Okay, so I don't have Facebook or I don't FaceTime or anything like that. So you'll have to explain to me why is that information not available just on Facebook and only on your phone?
I guess I don't understand the question that you're asking, but I no longer have a phone or that.
Okay,
So.
what I'm asking is that isn't Facebook like a cloud-based messaging service or app service or something like that? Facebook, it's out in the cloud, right?
Yeah, but if you're, it can be, but if I can't log into it anymore because of the phone broke, then, and I had deleted Facebook, so after everything.
Okay, so you could access it from a computer, but you just deleted it, right?
No, because it sends a link to the cell phone. It'll send like a code to the phone. If the phone that is on doesn't work no more and everything, I couldn't access it. No.
Okay, on March 18th, what time did he call you?
He called me at night. So that was probably like 2, 3 in the morning. Because he calls me when he's drunk.
And February 7th, what time did he call you?
That was at 2. I remember that one specifically being 2:22 in the afternoon because I was taking my friend to work. So I do remember that specifically being 2:22 in the afternoon.
And you were taking your friend to work? You were driving?
Yep.
And FaceTiming him at the same time?
That wasn't a FaceTime call, and I could answer with my steering wheel. And it was called over a private number, so I just answered the phone.
Okay, which date did you say was at 2:22 in the afternoon?
February 7th. When he said he was going to put acid all over me, and I never looked good for another man ever again. And he was mad because I was giving my friend a ride to work, and then he was going to divorce me and take everything from me.
on January 27th, you indicated that they were going to file a divorce and they were going to do specific things. Who contacted you? Was it Mr. McKediak or his girlfriend?
It was both of them. I mean, it was out of his phone, but it was both of them.
It was what?
Both of them.
But what did you say before that? It was off of what?
His phone?
It was from his phone?
I believe so.
Okay. And were all of these calls off of his phone?
Not all of them, no.
Were most of them from his phone?
One of them I know for sure was off his phone. But that one, I believe was off of his phone.
I can't hear you, ma'am.
That one I believe was off of his phone.
Okay, January 27th was off of his phone.
Yes.
Is there any other ones that was off of his phone?
I don't know if they're off his phone or not because they were private calls or sometimes they were, it doesn't mean it wasn't off of his phone. It could, like if it was private phone calls or off of somebody else's Facebook, I mean that wasn't off of his phone.
You indicated that on March 18th, I believe you said that he called you from a different, one of these dates he called you from a different number. Do you have that phone number?
No, I don't have the phone no more.
Okay.
My phone broke. I had to get a new phone. I don't have the phone no more.
Okay, so when did you write this this motion?
Sorry.
When did you write this motion with all of these dates on it as to what was said?
I wrote it back in March.
And how did you remember what was said on January 27th or specifically January 29th or any specific date?
Because I wrote it down. My phone broke after I filled like this out, but I wasn't expecting my phone to break.
I'm sorry, I didn't understand any of that.
I wrote things down, but I didn't like expect my phone to break. Or I had things saved in it in iCloud, like storage, and so. But I can tell you whose phone I know whose phone he called me off of. I don't know the number, but I know whose phone it was. Like a lot of times, like, you know, do you know people's numbers? Like we store people's numbers on our phone. I don't know nobody's number, but if it comes up somebody's name in my phone, okay, I know their name.
Okay, that's all. Thank you. I have no further questions.
Ms. McKediak, I know when you were giving cross-examination that you said you believe that the calls were from his phone. And what leads you to believe that they were from his phone?
Well,
and speak up, please.
So because it was him.
What was that? I couldn't hear you.
Because it was him, he called me off of his phone. I would believe it would be his phone.
Okay, well, that doesn't help me. I just want to know how you're saying he called you and you believe it was his phone. And you said you believe it was his phone because he called you. Hold on. You said you believe it was his phone because he called you. Well, somebody could have another phone and call you. I'm just trying to figure out how you know that it was from him, other than if you're telling me it was his voice, I understand that. But I just wanted to clarify your statement that you believe that it was his phone.
Well, because you could push *67. Like, I don't, you know, or download text apps, I guess. Like, I don't know. I would know it was him. So, but the one phone call I know was off of his phone. It was his phone number. It came up off of his number. And then another, you know, so I don't know.
Okay.
I just know that I get phone calls from him that are not very nice.
Okay. Other than your testimony, ma'am, do you have any documentation or other evidence of the phone calls as far as anything, you know, messages on your phone, any confirmation from your phone bills as the calls from him, anything like that?
I had emailed the courts some videos that were sent to me, but yes, you didn't get those.
Okay, I didn't hear most of that. So ma'am, what happens, you're not coming through very loudly. So we're having to strain to hear what you're saying. All I'm saying is project. If you have to shout, do it so that we can hear.
I said I had emailed the courts some videos, but I guess you didn't get those. I don't know.
We have no videos, ma'am.
Yeah, I had sent in that what evidence I had to the email that said to send it in. So I sent that evidence.
Anything else, ma'am, that you have? Again, anything from your phone bill showing calls from the respondent or anything of that nature?
No, I don't. You can't get things off of Facebook and stuff like that. So no.
Okay.
I do have one additional question from.
Okay, go ahead.
Thank you. Ma'am, what's your phone number?
26.
Is that the same number you would have had in February and March?
Well, I have a couple different numbers. I can't tell you, but I've got a few different cell phones for my kids too.
Okay, so which phone was he calling allegedly?
It's called my son's phone and my phone.
What's your son's phone number?
I don't know it offhand. Like I said, I got them stored in my phone, so I don't know them offhand. I have to look at my phone. Like I store the numbers in my phone as the names, and I don't know the numbers. I know my phone number and pretty much 911, but I don't know numbers like that, cell phone numbers.
So you haven't replaced your phone yet?
Yes, I just replaced it the other day. I had to go to Best Buy, but it took a couple weeks because I had to have an appointment. So it was broke.
Okay, so were your contacts transferred?
Yep, my contacts were transferred.
Okay, so since your contacts have been transferred, can you tell me what your son's phone number is? 15?
Yep.
Okay, I have no further questions. Thank you.
Okay. Ms. McKediak, just to clarify, is there any other evidence, any other testimony that you have to present?
Oh, I think he made that also a statement when we did the first court date saying how, I don't know, but that after the PPO was filed, he had said something about how that phone call back in January was made. And because that he tried to use that as him filing for his PPO, that phone call. So I don't know, I guess that's all I want to say.
Okay, thank you. Ms. Huffman, any evidence that you have to present, testimony otherwise?
I would just call Mr. McKediak.
Okay, Mr. McKediak, we'll have you raise your right hand, be sworn in, then we'll proceed. Go ahead.
Thank you, Mr. McKediak. Did you make any phone calls to
No.
Lindsay McKediak in?
No, you have all my documentation, my PDFs from Verizon.
Hang on. Let me ask you the questions.
Okay.
Did you make any phone calls to Ms. McKediak on January 27th?
No,
Did you make any phone calls to Ms. McKediak on February 7th?
no,
And February 11th?
oh,
Or March 18th?
no,
Did you make calls to her from any phone other than yours?
no. I
Did
didn't
you
make calls to her from my phone or
Okay.
any other.
And were you in contact with her via Facebook?
No. She has blocked off all my social media.
You have her blocked?
Yes.
And how long have you had her blocked?
Probably since at least before December of last year of 2023.
Were you in Florida on February 11th?
No.
And where were you on January 27th?
Michigan, home. Or I might have been on the 27th. I might have actually been on the road going to Florida because I want to say I turned in the rental receipts to you and I think I was back by the 5th or 6th. I'd have to go through my pictures.
Okay, could I share screen, Your Honor?
Yes, go ahead.
Thank you. Bear with me. It's the first time I've ever done this. Do you recognize this picture?
Yes.
And what is this picture?
I think it looks like of one of the bridges in Florida, and that would have been, I don't know. They're time stamps, so there's dates and times on the top of them.
So if this one says February 2nd at 11:06 a.m., would that be correct?
Yes, February 2nd. That would be on my way home.
Okay. And then this one is January 28th at 4:15 p.m.
Okay, that'd have been on my way there because I was only down there for like 3 or 4 days, maybe 5 days tops.
Okay. And so if you went down there on January 28th, if you were in Florida on January 28th, would you have left to go there on the 28th, or would you have left the day before and spent the night?
I would have left the day before because we were driving. What's Florida? 12-hour one way or more?
So you left on January 27th?
Yeah, I had to because we left. Yeah, I'm pretty sure that was.
And then, so if I had phone records here, would any of these phone records show that you have made any calls on January 27th from your phone to any of Miss McKediak's lines that she stated today?
Yes, the phone records are from Verizon Mobile. They're the PDF of the bill of every month. They show what time, where I'm at, where I'm calling to, and what number.
Right. I'm asking you, would any of them show that
No.
you called her at any of those 3 numbers that she gave us?
No, that's why I had them all printed off and turned into you.
Okay. And I do have them all saved on my desktop. I'm just not sure how to load them.
Okay.
But I will figure it out if I need to. March 18th, did you give me records that show all of your phone calls on March 18th?
I'm pretty sure every month that was listed from the first court hearing was turned into you.
Okay. And if I were to look through these and not find any of these phone numbers that were given to me, would that surprise you?
No.
In fact, none of these phone numbers are going to be listed on here, are they?
No.
Okay. And so that was March 18th, February 7th. If it states that you started making calls at 4:04 p.m. and you ended making calls at 7:16 p.m., would that be accurate?
No.
If that's what it says on here, would it be accurate?
What? Oh, yeah, on the PDFs? Yeah,
Yes.
the PDFs are from the Verizon company. You can't alter them. You can't change them. That's
Okay.
your printouts to pay your bill. Those are exact usages of my phone, where I was, where I'm at, and who I'm calling, and what times, and how long the calls were.
Okay, so listen to my question. On February 7th, if it indicates that at 4:04 p.m. you started making calls and you stopped making calls at 7:16 p.m., would that be accurate?
Yes.
Okay, and that none of those calls on here would have been from or to any of these 3 phone numbers.
Correct.
Okay. And the same with February 11th. Nothing on February 11th is going to show that you made any calls to Miss McKediak, is it?
Nope.
Ms. McKediak indicated that you contacted her on February 11th and that you FaceTimed her on February 11th and you were in Florida. Is that true?
No.
And by that date, you had already rented a vehicle in Michigan. Is that correct?
Yes.
And if it says that you rented a vehicle on 2/5/2024 and you returned your vehicle at 2/24/2024 from Kalamazoo - Battle Creek International, it looks like AP. Would that be correct?
Correct.
So if you were in Michigan renting a car, you would not have been in Florida. Isn't that correct?
That's correct.
Have you ever, either on your phone or anyone else's phone, indicated to Miss McKediak that you wanted to kill her or have someone else kill her?
Absolutely not.
And did you ever say that you would pour acid all over her so that no one else would ever want her?
No.
Do you have any reason to have contact with Miss McKediak?
Absolutely not. We're going through a divorce and I have a PPO on her and she has one on me.
Is there anything else you would like the court to know?
I mean, I apologize for their time being wasted today with these proceedings. You can read through the statements, see all the inconsistencies and everything, and we'll have to be doing it again because she's been contacting me violating her PPO.
Anything else, Ms. Huffman?
No, I would like to just make an offer of proof that I do have these.
Well, I'm not going to take an offer of proof. What I'm going to do is, if we're going to have to do that, and you can't submit them through the Zoom, which I guess, Ms. Huffman, I only admonish you in this matter. If you're going to submit something like that, you need to prepare to be able to do that. And the court's always available if somebody wants to call and check to see that the equipment works and their equipment works, et cetera. And so I'm not going to take an offer of proof when you aren't able to submit those, and you could have done that. Anything else, Ms. Huffman?
No, I have nothing further. Thank you.
Ms. McKediak, you have a right to cross-examine Mr. McKediak if you wish to do so. Do you have any cross-examination?
I just want to say you can rent a vehicle in Michigan and then go to Florida, and that is what he did. I mean, there was a
Ma'am, is this a question?
I guess is there does she have the receipts of when he rented the vehicle and where he returned it at? Is that
I have no idea.
or is that because he definitely called me and from Florida and stated that he was in Florida?
Okay,
So
that's not a question, ma'am. If you have a question for Mr. McKediak, you can ask your questions now.
what? Oh. I don't have any questions for him. I mean,
That's what I was asking. Well, what I'm going to do in this matter, and I'm not going to penalize Mr. McKediak because, go ahead.
I was able to pull up the Hertz. I have those up right now, the rental receipts. They indicate that he rented the, sorry.
Okay, what I'm going to do, because you can't get the other, and I think it is germane and important, and I don't want to penalize Mr. McKediak because Miss Huffman is not computer literate in this matter. So what I'm going to do is we're going to adjourn this matter to next Monday at 11 o'clock. I will have Miss Huffman make paper copies and submit all those proposed exhibits to the court in paper and send copies to Miss McKediak as well.
Ms. McKediak, would it be okay if I email those to you, or would you rather them be in mail?
yeah, that's fine. But I mean, I know what happened, so I don't need them.
Well, ma'am, they're going to be, she's going to, I presume, offer those as exhibits. You should have the exhibits. So if she's offering to send those, you can decline that, but it's up to you.
Yeah, I mean, why would I need them? I know he called me.
Ma'am, do you want them or not?
No.
Okay, thank you. Ms. Huffman, get those to the court though, so that we have those.
I will do that, and I do apologize. I'm sorry.
Okay, we will adjourn until next week at 11 o'clock a.m.
Thank you.